The Supreme Court of the United States is designed to look untouchable. Its 9 justices serve for life, physically and politically insulated from the messy reality of daily politics, passing down final rulings from behind closed doors. But behind those imposing marble columns is a massive constitutional vulnerability. The court can write the law, but it has no army, no police force, and zero physical capacity to actually enforce a single word of it. When the court ruled against the removal of the Cherokee Indians from Georgia, President Andrew Jackson simply ignored them. The ruling was legally binding, but without the executive branch to carry it out, the words on the page meant nothing. We saw this same vulnerability in the 1960s. When the court ordered the integration of public schools, local officials and state judges across the South actively looked for and found ways to dodge the mandate. Without the muscle to force compliance, the highest court in the land is fragile. Its power exists as a consensus sustained by public goodwill and executive cooperation. Because the justices can't use force, they have to engineer compliance by proving their decisions are sound. They have to show they understand exactly how an abstract legal theory will hit the real world. Long before the justices ever speak in public, they must sift through thousands of pages of complex written arguments. Many are amicus curiae or friend of the court briefs, submitted by outside groups injecting expertise. For example, in juvenile death penalty cases, justices weigh briefs from professionals and medical experts detailing adolescent brain development. The federal government also gets a say. The Solicitor General often submits a brief to explicitly lay out the United States' perspective on the issue, ensuring the executive branch's interests are formally weighed by the justices. This massive intake of outside perspective acts as a vital reality check. It prevents 9 isolated lawyers from accidentally issuing an unworkable mandate that the rest of the country might reject. Unlike a standard trial court, a Supreme Court hearing features no witness testimony, no new evidence, and no jury. Instead, the lawyers for each side get exactly 30 minutes at the podium to present their case. The justices already know the arguments. They've read the briefs. They use this time to relentlessly interrogate the lawyers. They fire off tough hypotheticals and probe for weaknesses, occasionally yielding a few minutes to the Solicitor General to voice the federal government's stance. It is an hour of highly visible, rigorous intellectual combat. This oral argument functions as a crucial piece of institutional theater, signaling to the public that every possible angle has been thoroughly stress-tested before a decision is made. Following the arguments, the justices retreat to cast a preliminary vote in secret. But it's the final written document, the majority, dissenting, or concurring opinion, that actually becomes the law. The most senior justice in the majority decides exactly who will write that final opinion, and that choice is a deeply calculated strategic maneuver. Consider a major mid-century ruling against voter discrimination in the South. The initial assignment went to Justice Felix Frankfurter, but Frankfurter was a Northerner, and the court knew a Northern justice scolding Southern states would face massive, immediate resistance. So they pulled the assignment and gave it to Justice Stanley Reed. Because Reed was a Southerner, his authorship provided regional credibility, making a harsh ruling far more palatable to the citizens it affected most. The written opinion is a carefully calibrated public relations document, meticulously drafted to persuade Congress, the President, and the masses to actually obey it. The justices might have lifetime appointments, but they aren't blind. They know that if their rulings drift too far ahead of American society or fall too far behind it, they risk losing their authority entirely. Look at the 1896 precedent of Plessy v. Ferguson. The court ruled that separate but equal racial segregation was perfectly legal, a decision that directly reflected the widely accepted social attitudes of that specific era. But by the late 1950s, the political ground had finally shifted. African Americans had served courageously in World War II, and new academic research was actively documenting the severe psychological damage segregation inflicted on children. Pushed by organized civil rights groups demanding an end to discrimination, these undeniable social forces left the court with little choice. In the 1954 Brown v. Board of Education decision, the justices unanimously overturned their own precedent. The Supreme Court does not dictate morality from a vacuum. It is a living mechanism, constantly calibrating its legal interpretations to match the evolving moral consensus of the American public.